We hope that you've enjoyed your participation in the conference so far. This is the Thursday morning session, Big Words, Important Concepts, Exactions and Rational Nexus, Annexations and De-annexation. And as we were chatting, we decided all this has an X in common, so we'll call this the X Factor session maybe. I'm Victoria Ashby. I work with the League as Director of Government Relations. And first we want to recognize our generous sponsors of this session, Rocky Mountain Power, and thank them for their sponsorship and support of the League. I am joined this morning by our presenters, Jordan Cullimore. He's the Director of the Office of the Property Rights Ombudsman. And I want to give the Ombudsman website a shout out. Like, there are some really great resources on the website, and if you haven't been to it before, I would definitely recommend checking it out. And then we're also joined by Wilf Sommerkorn, who is retired, but like everyone else I meet in this realm who's retired, he's not really retired. He's working part-time for the nonprofit Utah Land Use Institute and has over 40 years of experience before that, working as planning director and working for various cities along the Wasatch Front. So thank you for joining us. We'll do just a really quick poll to see who's with us today. So there it is. If you want to put in there who you are and who you represent, or not represent, but what your role is in the city, and let us know who's out there in virtual land. All right, if you get your votes in, and then we'll see what we've got there. All right, so Jordan and Wilf, looks like you've got 39% city staff. We've got mayor, a few more council members and mayors, some attorneys, state or county government, 12% planning commissioners, and the rest who are just conference junkies. So that's great. Welcome. We are going to start out with Jordan, and if you have questions, if you put them in the chat box, and then when Jordan is done, I will try and facilitate those questions and get those to him, and then we'll move over to Wilf, and same thing, we'll wait till the end of his presentation, but if you want to put questions in the chat box, I will try and keep track of those. So, Jordan, go ahead, thank you.
Okay, well, thank you, Victoria. I appreciate the opportunity to be here and talk about these closely related sister topics of exactions and annexations. Again, my name is Jordan Cullimore. I'm the lead attorney in the Office of the Property Rights Ombudsman, and I appreciate the opportunity to be here. Part of what our office does, just to give everyone an understanding, is we're a neutral, nonpartisan state agency that basically provides dispute resolution services in the area of land use and development, and also eminent domain. So being neutral, we help and try to assist both property owners and developers, as well as local governments. I see a lot of familiar names on the chat box here, and I appreciate our relationship with each of you. Again, I realize I'm probably I was telling Victoria and Wilf, I'm an opening act to the main show, considering what's been going on in the news lately. But I'll take a minute here to kind of present exactions, what that is, some of the common issues that we see. I was joking with my colleagues that I'm taking this conference really serious by virtue of the fact that I'm not only wearing a dress shirt, but you can't see it, but I am in fact wearing dress pants and dress shoes today. So that's how seriously I'm taking this. It's a very important thing, right? But all joking aside, so yeah, let me share my screen here. I do have a few brief slides to share on the Law of Exactions in Utah. Okay. So is that in full screen? Perfect. Okay, so jumping in to the Utah Law of Exactions, and I realize I saw there's a number of staff members on here today and planning commissioners. This is an interesting area of the law. It's a very practical area of the law, right? And I know that when we're talking about exactions, there's a lot of nuance involved, and there's a lot of gray area. And most of the time, there's not a lot of major questions, right, about exactions. A lot of the time, the local government and the developer are able to negotiate together and figure out situations that work for both parties. But sometimes there are disagreements, and that's primarily what I'm going to try to address is when a disagreement arises, right? How do you approach that, and what can you do to try to resolve those disagreements? So getting down to brass tacks, what is an exaction? BAM, development versus Salt Lake County. There's 3 BAM cases. You'll hear about BAM 1, 2, and 3. Those are kind of the seminal cases in Utah that outline the law of exactions. And they pull a lot from 2 U.S. Supreme Court cases, Nolan and Dolan. So you'll hear about the Nolan-Dolan analysis, and we'll talk about that a little bit. But this first language comes from one of the Utah BAM cases, and it says exactions are conditions imposed by governmental entities or developers for the issuance of a building permit or subdivision plat approval. The term includes any condition on development, including dedications of property, payment of money, installation of specific improvements, or other requirements imposed by a public entity. Additionally, the term includes conditions imposed by a legislative enactment, administrative decision, or negotiation. So I think it's important to note here. So yeah, that essentially is what constitutes an exaction. And a lot of the time, we're talking about things, the way I look at it is once you've given something that the local government is going to keep, that's an exaction, right? So when you're talking about reasonable restrictions through zoning regulations, most of that deals with height requirements, setback requirements, landscaping requirements. All of those requirements are reasonable government restrictions, right? Regulations that leave the property in the hands of the property owner or the developer, but restrict how they can use their land, right? And that's a lawful, as long as those requirements are reasonable, right? There's a very low standard that a local government has to meet to be able to show that their restrictions are reasonable, right? They just have to be rationally related to a legitimate government interest, not violate the Constitution or violate the law. Those are reasonable exercises of the police power that we talk about. But if when you have to give the property to the government, then a heightened level of scrutiny applies. And that's what we're going to talk about today, is that heightened level of scrutiny, the rough proportionality test. So getting into that, the rough proportionality test, an exaction is validly imposed when it satisfies the following 2-part test. And this, again, like I said before, it comes from Nolan and Dolan, the U.S. Supreme Court cases, but it's been specifically codified in Utah law, in state law. And it says a municipality may impose an exaction on development proposed in a land use application if, so there's 2 parts, right? An essential link exists between a legitimate government interest and each exaction. And then the second part is each exaction is roughly proportionate, both in nature and extent, to the impact of the proposed development. So I could probably end the presentation right there, and everyone is very clear on what an exaction is and how you apply it. The reality is that there's a lot of legalese there. And so hopefully we can kind of talk about what each of these means and how they apply on a day-to-day basis in your work, considering applications. So the first part is the essential link, right? An essential link must exist between a legitimate government interest and each exaction. So I like to think about, when you approach these questions, what questions should I be asking to determine if I comply with this test, right? what legitimate government interest does the requirement or the exaction address? And then the second question is, will the requirement reasonably accomplish the governmental interests objectives? And so the context that this came up in initially in the Nolan case at the US Supreme Court, it was out of California. It was Nolan versus the California Coastal Commission, right? And they were in charge of kind of regulating development, and they still are, as far as I know, along beachfronts in California. And there was a situation where a property owner, essentially, as I remember it, wanted to replace, it's like a 500 square foot bungalow with a 2,500 square foot beach house, basically. And so they submitted an application to do that. There was an ongoing concern among the California Coastal Commission that people know, citizens of California know, that they have a constitutional right to access beaches. Apparently the Constitution in California allows people to access their beaches. And in certain areas along the beach, there was just this wall, right? There was all these beach houses. And so it created what they termed a psychological barrier. So the people on the other side of that wall didn't realize that they could, if they could get around those houses, they had a right to access those beaches. And so that was what the California Coastal Commission was purporting as their legitimate government interest, is letting people know that they could access these beaches, that they could use these beaches, and to try to prevent this psychological barrier from doing so. The problem that arose was that the California Coastal Commission cited to that interest, but the exaction they were imposing was an easement on the beachward side of the property of the beach house that would run between one public access beach to another public access beach along the property owner's land. And so the exaction was to connect two beaches, and it had nothing to do with the stated legitimate governmental interest of preventing this psychological barrier that people had to get to know that they could use the beach. And so the U.S. Supreme Court in that case said there isn't a link, right, between what you're requiring and the legitimate government interest you're pursuing. And so they established this as kind of the primary and the first step to determining whether an exaction is a legitimate exercise of the police power, or if it becomes an unlawful exaction. And they said if there's no essential link, then it's basically, I think the term they use is an out and out plan for extortion, right? It's just an opportunity to say, hey, you need a permit, we need this, give it to us and we'll give you the permit, right? They said you can't do that. There has to be a link between the governmental interest and the requirement you're imposing. And honestly, in our office, we don't really see too many violations of this part of the test in what we do, right? Most of the time, it's because the development is causing an added impact on transportation services. And so, you require a road, or there's going to be additional impact on sewer or water, the ability to provide sewer and water. So you're requiring those types of improvements. As long as you're doing that, as long as you're not acting for something out far in left field unrelated to development, the essential link is likely going to be met. And so, yeah, if the requirement reasonably accomplishes the interest objective, this part of the test is satisfied. The second part is rough proportionality. The exaction must be roughly proportionate in nature and extent to the impact of the proposed development. And Utah courts have emphasized that this analysis involves two aspects. One, the exaction impact must be proportionate in nature, and it must be proportionate in extent. So we'll get into the two of those. And again, the basis of this was in the U.S. Supreme Court case of the Dolan case. And briefly stated there, the issue in this one was the Nolan case had come out, and people were following that. And here, the governmental entity was imposing a requirement on a property owner who wanted to replace their commercial building. And they said, hey, you're doing a new parking lot, and you have this floodplain on your property. So we're going to impose two requirements, right? You're going to have additional traffic, foot traffic, and specifically, so we're going to impose a requirement that you install a bike and pedestrian path and dedicate that to the city. And then we're also going to require you to dedicate part of the land in the floodplain for a greenway that the public can use and access so that we can control the flooding there. And while those met the essential link component, the court also said, well, there also has to be, we also need to talk about degree, right? And your requirement has to be proportionate or equivalent to the impact of the development is creating. And so in that case, they said, look, you don't need to have the property owner dedicate the floodplain for a greenway that the public can use. You could have just imposed, a requirement that nothing be built there to keep the floodplain open, or a conservation easement of some sort. And then furthermore, they actually even struck down the bike and pedestrian path, saying that it was speculative that traffic was increased in a way that warranted the imposition of a requirement that they dedicate this bike and pedestrian path, which kind of gets to our next point. With the rush proportionality test, while no precise mathematical calculation is required, the government entity has the burden of making some sort of individualized determination that the required dedication is related both in nature and extent to the impact of the proposed development. And again, I recognize that in a lot of cases, I had one local government one time in a mediation ask me and say, hey, do we have to do this every single time we impose an exaction? And I don't think you do, right? Again, if everyone is on the same page and feels comfortable that the exaction is appropriate, then you can move forward, right? But when a dispute arises, it is the local government's burden, and they do have an obligation that while no precise mathematical calculation is required, you have to make some sort of individualized determination that the dedication is related to the impact, right? And that, I think, comes from that idea in Dolan that it can't be just speculative, right? You do have to do something to try to show what the impact is and how you're addressing it, whether through studies or otherwise. So getting into the two aspects of rough proportionality, the nature aspect, it's analyzed in the context of a problem and a solution under Utah law. So questions to ask: what problem or impact or burden will the city bear as a result of the development? And does the solution or requirement reasonably address that problem? And in my mind, this one's actually pretty closely related to the essential link idea, but it just goes back to that same concept of, if you need to offset, an increase in a traffic burden, are you requiring a road, or are you trying to require something else? The impact, the exaction has to solve, which is the solution, has to solve the problem, which is the impact being created by the local government, or by the development, excuse me. And if the requirement addresses the impact, then the nature aspect is satisfied. Getting into the extent aspect, it compares the burden on the city produced by the impact of the development against the cost to the developer of the required improvements and dedication. So questions, right? What costs will the city likely incur to mitigate the burden produced by the development's impacts? So you're looking at the situation, you're saying, okay, this development is coming into town. What are we going to have to do to provide this development services in the same way that we, according to our level of service, basically, right? And then you look at how much will it cost the developer to install improvements or dedicate land to mitigate the development impacts. Ideally, right, you can attach, what the courts have said is you attach monetary costs to this. And I put a line from one of the BAM cases. It says, our trial courts are very adept at figuring out costs in similar situations and are more than capable of adjudging the costs of each factor in this context. What we found is local governments just don't have the same resources that courts have, right, to attach monetary and specific costs to development impacts. Ideally, and in court, that's how you're going to resolve it, right? Is you're going to say, okay, this is the cost of the local government of assuaging the impact of the development, and this is how much the developer is going to pay to put in these exactions that are being imposed. And though if those costs are equivalent, then you satisfy the test, right? Hopefully you can find other ways, though, to make these arguments. And if you have questions about this, probably the best course of action would just be to call our office, and we're happy to have the conversation with you about what may or may not be roughly proportionate. One of the things that our office has done, and again, as a yardstick, we've identified that, hey, in most cases, everyone seems to agree, and it's customary that if everyone, specifically in the context of residential development, if everyone covers the cost of, curb, gutter, and sidewalk and a half width of street improvements directly in front of their property, if everyone did that, then everything would be accounted for, right? But individual circumstances sometimes warrant either more or less, depending on what those circumstances are, right? And so that's where sometimes it gets into the need for additional analysis. But the idea is that if the costs are roughly equivalent, then the extent aspect is satisfied. So that's the rough proportionality test. I thought I'd briefly talk about some common issues that we see and run into and experience in advisory opinions we do, and in situations that we encounter when disputes arise between property owners and local governments. One of the things we often see is we hear the words, the local ordinance says we can require it, right? It's important to realize that just because the local ordinance says you can require it, it doesn't mean that the Constitution does, right? And the Constitution is going to overrule the local ordinance, right? So you still have to do that analysis. But this is often something we see is we just want to rotely impose this requirement on everyone, right? And that's kind of the second thing we see is we require this of everyone, right? But like we talked about earlier, you have to make an individualized determination depending on the specific impact of the development being proposed. Another issue we see is one of scale, and this is just something I point out to be aware of. Here I just put up these two different scenarios. There's the one on the left is a master plan development that both of these I just pulled off of the internet. They're not anything in Utah. But in that case, with a larger development, there's in my experience, there's usually not a lot of disagreement about what the developer is going to be responsible for within that development, right? In order to give access and services to all of those lots, they're going to need to provide those internal roads. They're going to need to, bring sewer and water. They're going to need to do storm drainage. They're going to need to provide all of those services, right? But when you reduce the scale, in my experience, that's when a lot of the questions start arising, right? So let's say you just have a 2-lot subdivision, and you're requiring, all this road frontage, and let's say even that, hey, there's going to be a parcel behind them that may be landlocked, so we also need a road between those 2 lots, right? Those are the kinds of issues that start raising red flags and begin to potentially run afoul of proportionality. So I always caution people that the smaller the scale, the higher the likelihood you might be out of proportion in what you're requiring, especially if you're just imposing the requirements from the ordinance in every case. So that's just something to think about. And then the last issue that we run into frequently is this, we call it the pioneering problem. And this is a question, maybe some of you were in our Ask the Ombudsman session yesterday. This one came up. I'm presenting it here for a little bit different of a reason, but this is a question we see not infrequently. As an example, I'm wondering if you could discuss rational nexus in relation to development requirements and standards, and maybe use some examples. Occasionally, we have a proposed rural development on a parcel with limited access that doesn't meet our adopted road standards. For example, there is only a 30-foot right-of-way, and the developer is proposing a 4-lot subdivision, which requires a 60-foot right-of-way based on our adopted standards. Can we require the developer to acquire the additional right-of-way to access their property? So the way I read this and the way I understand it, and the question that we often get is, hey, we have this property owner who wants to do a subdivision out here, right? And all of our services and our kind of our development, where our development comes to is over here, right? And we have this substandard road that leads out to that development. And our fire code, for instance, says that you need a bigger right-of-way to get out there, right? So can we require them to expand the entire width of that road and go out and acquire the right-of-way and get it, bring all the services out, you know, do everything they need to do to get everything there? From the standpoint of exactions, it's probably excessive, right? But at the same time, local governments are within their rights to say, hey, you need to meet code requirements before you can develop. So we look at the pioneering problem as largely an issue of timing and sequencing, or if you've heard of the term adequate public facilities, right? So while it may be an excessive exaction, the pioneering problem is that you also need to consider the fact that for that development to be ripe and able to occur, it needs to have services coming to it, right? And so there's different ways to solve that problem. Sometimes the developer just has to wait until development catches up with his property. Other times local governments will allow, and you guys are probably familiar with this, pioneering or reimbursement agreements where they say, hey, for a period of time, we'll identify this area that you've improved and say anyone else who hooks into that at some point in the future, you're going to need to reimburse this property owner for those types of things. So this issue comes up in the context of exactions, and it's important to recognize and try to address it in an appropriate way. So that's all I got for exactions. And if you have any questions or if there's anything else, let me know.
Thank you, Jordan. That was very helpful. I think that last example is a great one. And I think I hadn't ever really thought about the proportionality issue being a bigger problem on smaller projects, but it does make sense to a certain degree. I have not seen any questions in the chat box, so you have covered the whole spectrum of exactions law. So thank you, Jordan. So we'll go ahead and turn time over to Wilf. And again, if you have questions, put them in the chat box and I'll pitch them at the end. Thanks.
Well, thanks. I was hoping Jordan to get some questions, so it'd take up a little more time. But as it is, we'll move forward and go ahead. Jordan mentioned that he was taking the conference so seriously that he got all dressed up for it. I did not. I'm not going to show you the camouflage shorts that I'm wearing. I think you would all leave the session quickly if you saw that. So it's a good thing you can only see me from about here up. And we'll move forward from there. I was asked to do this session on annexations, and I think in part because annexations have kind of become a hot issue in the last year or so. Annexations kind of go through cycles, and it always seems to be at times when there's a lot of growth that it becomes a big issue again. But the annexation process itself is a relatively simple one, but it gets balled up in a lot of different kinds of issues and so on, depending on what's going on. And as we were chatting a little bit before the conference session starts, Victoria was indicating, you know, she says it's oftentimes a really localized issue, and it is. It kind of depends on what's going on right around the area where there's development going on, where property owners have different desires and wishes and what to do. Annexation, of course, is the process by which cities grow. They add area and development and population. When many of our cities were first established, they were fairly isolated. And at some point, they established formal boundaries. So these are our city boundaries. And the area within it is an area that we govern. Areas that were outside of it, they might interact with the community, but they were not formally part of that particular community. As growth kind of chugged along, not particularly fast, various property owners that were living outside of the city may have had a desire to join with the city, either because they wanted the services that were being provided by that particular city, or they wanted just to associate with the city. And so they might petition for annexation. There might be any number of reasons. In some cases, and particularly this got going in years probably more so in the mid 20th century and then thereafter, as growth started to pick up, some of that property was starting to be developed. And as development occurred, oftentimes those property owners, of course, and those who would be buying the property had the desire to receive, or not even the desire, but the need to get the services that were being provided by the communities so they could provide good, viable communities and places for people to live. And so then the annexations might be sought after so that they could get those services. It's a little bit of a mixed bag, because you also had situations and instances where the officials within those cities had a desire to control the property around them so that they would be able to have some say as to what kind of development might go in the area around them. And so they would seek to annex. They also, as growth would continue, they saw the opportunity perhaps also for revenue as new development would occur. And as it might occur on the edges of their community or just outside their community, to incorporate that or include that in their community through the annexation process. And so you had a little bit of a dynamic that would set up as to whether to include a property or not. You eventually probably got to a situation where people that lived outside of the county, maybe they'd want to be part of the city, maybe they wouldn't. Generally, properties that are outside of the city boundaries would have a lower tax rate. They have a lower tax rate because they're generally not getting the level and kinds of services that are provided inside the community. And so the revenue's not needed there to help fund those. Things like sewer and water services and stormwater services and public utilities, and enhanced and improved public works, recreation opportunities, parks, and perhaps enhanced police and fire protection services, things that were set up and usually done within the communities. And the structure of our local governments was such that it was easier and even encouraged that those kinds of urban services would be done by municipalities, cities and towns, rather than by counties, for a variety of reasons, among those being that you have more people living in those communities, therefore better to distribute the costs and make it more cost effective. So sometimes people who are outside of the city, they might not want to be annexed because they didn't want to pay the higher tax rate. Maybe they wanted those services though, and so then they would be willing to annex. And particularly if they were looking to develop their property, those who would want to buy that property may very well want those services that are available in the adjacent community, so they might seek annexation to do that. A lot of different situations would occur that complicated the issue. Many communities were small and could not necessarily afford cost effectively to do things like provide a wastewater treatment system. And so those kinds of things, or even a water system. So those kinds of things were often done by a larger group in a special service district. And those districts would serve several communities, as well as perhaps the area that was not included in a city or a town. And so that kind of complicated the issue, because now you had people that were paying for those services, but they weren't necessarily within the boundaries of that community. So they might then be able to go ahead and develop and provide the water system without having to annex into the community. Same with school services. All of the kids that live in a particular school district, whether they're inside the city or outside the city, would be eligible and would be getting the services from that school district. The schools were often located within the city boundaries. And so there were some costs associated with getting kids to and from school, providing the necessary services and so on, but then people might also be living outside the city. So the whole situation kind of got more and more complicated as to whether property should be annexed or shouldn't they be, and when and how. And particularly as we've faced times when we have fast growth, then the issue really becomes a lot more complicated. Not only do you have the issue of the urban services, but you also have the communities wanting to control or wanting to at least have some say in what goes on their boundaries. And whether they're able to do that or not depends on whether that area is within their city boundaries or not. And so it would oftentimes make sense, because frequently and outside of the city boundaries, if urban development would go into those, would develop outside of city boundaries, it would oftentimes not have the services. It would not have some of the things that those inside the city boundaries would have. Frequently, they would also have lower costs as well. So it became kind of a complicated situation, whether they should or they shouldn't be part of that. That's kind of what happened as growth really picked up in the 50s and 60s. And you had the special service districts that were now providing some of the services like water and sewer, and particularly some of the hot urban counties at that point, like Salt Lake County, where there was not really a conscious effort to make sure that new growth would occur within city boundaries, but was allowed to happen in the unincorporated areas of the county. And pretty soon there was a lot of growth that occurred, not only within the cities themselves, but outside of the cities, including a lot of commercial development. And so at one point in the 70s and 80s, the unincorporated area of Salt Lake County was essentially the largest city in the state. You had some 220,000 people that lived in the unincorporated area of Salt Lake County in typical subdivisions and typical commercial development that would occur there. Now, what began to happen is that some of that commercial development, it generates revenue, and cities, through their annexation powers, were then able to talk to those property owners and convince them that they might get better services within their community, and they would begin to annex these commercial areas. But oftentimes they took the commercial areas, but not the residential areas that generally frequently cost more to service than the revenue that they produce. And so we had a situation where a lot of these commercial areas were being annexed into the cities. The residents were being left in the unincorporated county areas, and the county was losing revenue to be able to provide the services to those residents. Those residents were beginning to feel it as well. And we really had a situation that developed where that I characterize it now, I call it the Annexation Wars, that really broke out. It was such a big issue, and because of the state code on annexation, it's whenever we have issues like this that all of a sudden now the legislature, the state level policy folks begin to pay attention to these kinds of things, because their constituents are raising concerns and issues. And so we had a lot of ideas that were being kicked around and threats that were being made, and restricting the powers of annexation or making certain requirements about how annexation might occur that really then mainly affected Salt Lake County, but because of the state code applying to everybody in the state, they were affecting all others in the state as well. And so now we had a two-track system where those in Salt Lake County were fighting over their annexation issues, and those outside of Salt Lake County were saying, we don't have those kinds of problems, leave us out of it. And eventually what developed was a two-tier system, where we had a system of annexations for Salt Lake County that grew really, really complicated and unwieldy, and the system for everybody else in the state that kind of got affected by it as well, but not to the same degree and extent as what happened in Salt Lake County. And the whole thing blew up in the 90s. When the wars really reached a crescendo, and there were impasses in the legislature, and then finally, at one point, after the collapse of several different proposals and negotiations, the Speaker of the House and a couple of folks came out at the last minute in the legislative session with a proposal to create a new entity called townships. That really nobody had had a chance to vet, but it was kind of put on the table as a last-minute solution, and it passed. Because the threat was, if we don't do this, nothing's going to happen, and you'll be in a bigger mess the way things are at. Well, that whole concept not being very well vetted didn't work real well and caused a lot of problems. And then the next legislative session, the legislature repealed it. and then actually basically had to come back and reinstate it with a new set of rules. It really turned into quite a mess. Things kindly eventually got patched back together, but we kind of live with the legacy of what happened in the 90s in our annexation laws in the state of Utah. And definitely we still have that two-tiered system where there's a system of annexations for Salt Lake County and a system for everybody else. It's sort of limped along and has been working reasonably well for a good period of time. It's been working okay. I don't know that I would say it's working well. But every so often, when things happen, then we kind of get attention paid to it again, and there are proposals made and things are kind of slapped together again. And that's sort of what happened in this last year's legislative session. We had a few issues that were boiling again in several different places as it happened, and several different proposals were made in the legislature to make some changes to the annexation code and the annexation laws. You know, I'm kind of going back and saying this whole process of annexation, it really speaks to the issue of how to deal with urban growth. As an area is developing, particularly metropolitan areas are growing and developing, and how do you deal with and manage that growth? And communities, of course, have their own land use codes and regulations as to how they deal with it. Variations in each community, each one kind of does it a little bit differently as they see what might work best in their community, but there are a lot of similarities and it works pretty well. The thing that we've had a harder time dealing with is, what do you do with that land that's outside of the community that's ripe for growth, that the property owners want to see developed, that is ready for development, and there's a dynamic that's almost set up between the property owners that are outside of the community. Excuse me. They may prefer going into one community over another because they like their rules better, or they like what they're assessing for costs better than another one. But it may make more sense for that development to be in a particular community. Or in some instances, you may see the property owners go ahead and say, we want to develop and not be part of any of these existing communities. And because of the various service districts and things we have in place, they can sometimes do that. And is that really the best way to manage our urban growth? And so there are some interesting papers out there that have been written and proposals that have been put forth about what's a good way to try and deal with and manage this kind of growth. And there are a couple of different concepts to it. One, which would basically say that cities ought to have the ability to just unilaterally annex on their own without the say-so of the property owners. Because the property owners are probably going to try to play the cities off against each other, or try to do things that's going to be the least expensive for them, but may not be the best in the long run for the way growth is managed in the area in the long term. That kind of a situation has existed in several states around the country, and but it's kind of changing because of the really the concept of the belief that people deserve some representation, to have some say as to where their properties go and what happens with that property. Property owners that are within communities, they certainly have a say as to what zoning ordinances and land use regulations are put in place by the hearing process and by their ability to vote for the elected officials. And so that if the argument is made that the same ought to extend to those other property owners. And so there have been some different ideas of saying also that that kind of representation can be given by allowing for other representatives, say the county elected officials, to have some say over what happens in the annexation. But also that there ought to be some kind of more of a metropolitan level area review. At the very least, there ought to be some serious standards set forth for the way growth and development happens in metropolitan area, and what the standards would be, and if those standards are met for when new growth is proposed, and what community it ought to happen in. That kind of is spoken to in our state code in all of those issues in a couple of different ways. In the Utah State Code, communities are required to develop what's called an annexation policy plan. They've been required to have that in place for some time. Properties that they propose to annex are supposed to be included in their annexation policy plan. And there are a number of things that a community is supposed to look at as they develop their annexation policy plan to accommodate new property, new growth, and how to do that. That works reasonably well for those communities that are serious about it, but there's not a lot of attention paid to it, quite honestly. A lot of times a community may do something perfunctory on it just to kind of say that they've checked that box. And perhaps there ought to be some more serious consideration given to that. There's also not a real good mechanism in place to say if there's an area between communities that could go to one community or the other to basically say which community would it be better to be in, and for there's some kind of a negotiation or some kind of process by which the two communities look at that and come to some type of agreement as to where the boundary between the two communities ultimately ought to be. That's perhaps something that ought to be looked at and a mechanism put in place for that as well. But there is something in place in the state code with regard to that for the annexation policy plan, but there are some things that could be done to improve it. Now, as to the question of urban development that occurs outside of the city boundaries in the unincorporated areas, some areas have allowed for, and in fact, in the state of Utah at one point, there was a provision that municipalities could exercise what's called extraterritorial authority, that they could have regulatory authority, land use regulation generally, for a certain distance outside of their boundaries to deal with that issue of new development being proposed that's not within their boundaries and may not necessarily seek to be within their boundaries for whatever reason. That was removed a number of years ago, I think probably during the Annexation Wars. That was one of the things that was cast out. But the state code does have in it some provision now that does require, when urban development, and there's a definition of urban development in the code now, when urban development is proposed within the what's called the expansion area or the boundary expansion area of a municipality, that before a county can approve that, they need to notify the municipality that there is a development proposal coming forward and that they're considering approving it. Then the municipality has the opportunity to comment on that, to raise objections to it. And then the county is required to respond to those concerns. But they're not prohibited from not approving the development. So there is a little bit of a mechanism in place to try and address that concern about having urban development occur outside of city boundaries. But it's not something that is a particularly strong mechanism, and there may be good and bad reasons for all of that, but it really is something that I think deserves some look, some more consideration as we move forward with future urban growth and development. So those are some kind of the ideals. There are the things that exist in the state code, some of the issues that we have. We also have the issue if you have a dispute over an annexation proposal. And the dispute in this case really ranges between jurisdictions, so between two cities, say, or if a service district has some concern with what might happen with a proposed annexation, that protests can be raised and the issue thrown to what's called a boundary commission. Every county is supposed to have a boundary commission, and that boundary commission has the authority to take a look at such proposed annexations and make a determination as to how to kind of settle that, how to adjudicate a dispute between entities about a proposed annexation. And so that's a mechanism that's kind of in place in our state code that works reasonably well depending on particular kinds of issues as to how to deal with it. Disputes over potential annexations. Our state code also allows, of course, for those who may be within a municipality to withdraw from a municipality. And if it's amicable, it can be done relatively easily. If not, it requires a court settlement, requires a court ruling in order to determine whether a property can be removed from the jurisdiction of a municipality. And then we have the whole issue that really kind of first initially came up back in the 90s about municipalities being able to annex across county lines, across county boundaries. If you've been following this at all, you know this is a big issue right now, one of the big issues here in the state of Utah. And there are some pros and cons to that, but one of the big issues if a municipality annexes across county lines is that you may very well face a situation where you've got residents in the same municipality, in the same community, that have very different situations in terms of how they vote, because voting rules and voting systems are really handled on a county by county basis. And so people in one part of the community may vote a certain way, and people in another part of a community may vote a different way. They have different tax assessments and levies and processes in place. A number of things that may be different by being in different counties. And the issue really caused some concern when there was a cross-county boundary done when Draper annexed over into Utah County, which then wound up being addressed at the legislature, and the legislature put a rule in place that said that cross-county annexations can only occur with the consent of the county governing body of the county in which the annexation is being proposed, if it's outside of the boundaries of the main part of the municipality. And so that was put into place a number of years ago. Now, as I mentioned, as I said, the issue of annexation kind of comes up in the legislature every so often when there are hot issues. And this last year, we had about 3 or 4 different kinds of hot issues that came up. And so there were several changes that were made in the legislature. And one of them was the cross-county annexation. The cross-county annexation, though, really wasn't the main part of the bill. The main part of that bill addressed another issue that had more to do with the ability of, if there is a proposed incorporation of property in the unincorporated county, and some people don't want to be part of that incorporation, or for whatever reason, then they might seek to annex to another community, whether you can have an annexation competing with an incorporation. And that was the main purpose, or the main thrust of the bill. And that was a bill that passed this session, which basically said that if there's an incorporation pending with a study going, that you can't have annexations that will kind of take out area from that proposed incorporation. But then this cross-county line issue was kind of amended into the bill at the last moment, which caused some concern there. We had another issue where annexation code generally requires that in order for a property to be annexed, it has to be contiguous, and it has to be adjacent to the municipality in which it's going to be annexed into, and not leave islands or peninsulas. Problem is that sometimes you have property owners that are desiring to develop, but they may not be directly adjacent to the municipality. And the intervening property owners don't want to annex. The city's willing to annex. The property owner that wants to develop is willing to annex. But what happens in between? And that was causing some issues and some problems. And so another bill this last session allowed for non-contiguous annexations of property that would leave islands and peninsulas to kind of get around this issue. But again, it requires the consent and agreement from everybody involved, from the county, from the municipality, and the property owner to be able to do that. So that was another bill that was addressed. And then, let's see, we had another bill that was looking at the issue of development in the unincorporated county, and made some changes in regards to that, with the notification that has to be given to the municipality by the county and what's considered to be urban development. So those are some of the changes that happened this last legislative session. Because of those kinds of things, there are efforts afoot right now to look at making some more comprehensive changes and some other specific changes to the annexation code in the upcoming legislative session. Victoria Ashby with the League is administrating the land use task force, which many of you I know are familiar with. And they're looking at those issues. And I'm going to throw it to Victoria right now to describe briefly what kinds of changes are being proposed in the annexation code for this upcoming session. Victoria?
Thanks, Wilf. So we've had one question come in that I'd like you, if you can, address before I dive into that. Von Pickle asks, can you address whether property owners can be forced in with an annexation petition?
Yes, they can be. They're under an annexation petition. It can take in an area. The petition has to be signed by a majority of the property owners or a majority of the owners of the valuation of that property. People can protest, but if the protests are not enough to be either a majority of the property owners or a majority of the value of the properties, the community can agree to annex that property, even though there are some property owners who don't want to be annexed. They can be forced in under a situation like that.
Great, thank you. And then we've had another question. Could you tell us what the code section is for the non-contiguous annexation? And I was trying to find that real quick. And if I do, I will paste it in the chat box. It's going to be in Title 10, Chapter 2, Part 4 somewhere. I just have to remember where it is. I think it's in
402, but I'll take a look again just to make sure.
Okay, okay. And then there's another question from Casey Arnold. The new wording in the code would not allow for an incorporated island to be annexed, correct?
For an incorporated island? Yeah, I think that's right. The Utah code does not allow for one municipality to annex another part that's already incorporated. Can't happen under Utah law. It is possible in some other states, but not in Utah.
Okay. And then to the previous comment, Jeff Nelson mentioned, in follow-up with the force, we have an issue about real property being able to be forced in. And then Casey said, sorry, I meant we cannot annex a property that is an island. So it looks like unincorporated island. So
an unincorporated island, first of all, annexations have to be initiated by the property owners. That's the mechanism in Utah State Code. However, there is a provision in the code that does allow for a municipality to annex without a petition if it is essentially an island or a peninsula. It's an area that's adjacent to the municipality, and the municipality has been providing urban services to that property for more than a year. If that's the case, then the municipality can annex that property without a petition. But that's about the only situation I think that can be done by.
Okay, thank you, Wilf. And I've just pasted in what I think is the language for the non-contiguous annexation in 102402. Okay, thanks for those great questions. So yeah, Wilf mentioned that the land use task force is one of the items it's looking at is annexation. Representative Waldrop, who was the sponsor of HB 359, which was the bill that passed at the end of session, was substituted, allowing the cross-county annexation. He's kind of leading up this group, and a lot of that looks like I pasted it privately, so I will try and paste that again to everybody. Sorry about that. He's leading up this group in part because of what's happened with the bills during session. And Wilf mentioned that when these local issues trickle up to the legislature, then the legislature gets involved. My own personal commentary would be that it's not always great for the legislature to try and deal with these issues during a special session, but that is what they've done. Despite their protests that special sessions this year were only to address COVID, I'm not really sure how COVID accelerated the annexation and incorporation needs for legislative action, but nevertheless, they did. And there has potentially been some buyer's remorse during that process, in part because these special sessions have all been done online, and it's really hard to vet bills which come out quickly. But nevertheless, here we are. So Representative Waldrop is leading this group. And the annexation group has broken up into smaller groups. So the topics that they are looking at is the cross-county boundary annexation issue. What's really the best way forward when a city is reaching across county lines? And, you know, there's a sentiment that county boundaries do have purpose, but there are also constructs that we have created. And so are there good reasons to stop a city at a county boundary? What should the other counties' participation be in this process? How much say should they have in it? Should a person who is driving this annexation first have to look to the cities within their existing county before they try and annex over and work with those cities first, or should they be able to just jump across the county boundary and annex that direction? And it's a tricky issue, and we've got a group working on it, and you know, seeing what the right balance is of property rights and predictability, which is kind of like the big arching issues in a lot of this, the property rights, and then how do you predict how a city is going to grow or where a city will exist? The next group is looking at notice. There's some sentiment that there's not good enough notice being given in the annexation or incorporation process, that in some cases only certain property owners get good notice. And so do we need to change the notice requirements that are in statute? Another group is looking at what's often called boundary protection, and Wilf touched on this. That's when you have a group that's already started an incorporation process, and then there are property owners within that identified area who actually would rather annex to the neighboring municipality rather than be in the new municipality. And this has come up this year. You've seen this issue out in Tooele County in Erda. There were a group of property owners who wanted to incorporate to create a new city, and there were property owners who were drawn into that boundary who did not want to become part of the new city, and so filed annexation petitions. SB 5004 in the, I think it was April special session, was trying to address this issue. What is the cutoff of when you can no longer try and annex out of an incorporation? And the problem with this is that once you have that incorporation area drawn, it takes a while to incorporation happen, and annexation is on a faster track. But if you have people pull out of the drawn area for the incorporation, it disrupts that map that the initial incorporation parties were looking at. And so if you're the poor lieutenant governor having to deal with the election this year out in Tooele, you have an incorporation that now has pockets in it that have been pulled out through annexation attempts. And there is some question if some of those annexations were good faith, or if those property owners use the annexation process to get out of the incorporation, but actually don't ultimately want to be annexed by their neighboring municipalities. So it's a really tricky issue because you're trying to, again, respect property rights, but create predictability at the same time for these different political subdivisions that are impacted by these drives. And one of the tricky things is that incorporation, although it's started by property owners, it ultimately ends up in an election. And so the people within that drawn boundaries of the proposed new city go to the ballot to decide if they want to become a new city. Annexation is different. There's no election on an annexation. It's just driven to that municipality's legislative body to make a decision. In an incorporation, you may have large swaths of property where the property owner doesn't actually reside within the new city. So they don't have a vote necessarily when their property gets drawn into this new city. Should we change the law on that? Should there be a different mechanism? Should they be allowed to vote even though they're not residents? These are just some of the questions coming up with that boundary protection group. And then finally, there's a group looking at, okay, so we have now opened Pandora's box. We are asking questions fundamental to all of the incorporation and annexation processes. How do we hit the pause button, or how do we make these changes without disrupting efforts that are already ongoing? And you kind of, if you follow the news up in Hideout, Wasatch County, Summit County, there's a lot of timing that goes in. There's development interest, property interest that may be at stake when we start changing the annexation and incorporation laws. What should we do should we stop, hit the pause button, try and figure out a way to vest those who are already in the process, and then recodify or re-question all of this annexation and incorporation code? And one of the reasons to look at a recodification, and in my previous job at the Office of Legislative Research and General Counsel, I do not throw out the recodification word lightly. It's a big undertaking, and it can cause havoc in the code, and it's not easy for those drafters or those practitioners to deal with. But as Wilf said, lots of this code has been cherry-picked, mostly for Salt Lake County over time, but now we're seeing the issues that Salt Lake County was facing happening outside of Salt Lake County. And should everyone have the same rules, or do we still need a bifurcated system? What should that code look like for annexations in particular? So that's what those groups are looking at. Whether or not we'll have something substantial to have in this session remains to be seen, but they have been meeting quite a bit. And I see one more, I think, question from one of our people. Let's see here. Can panelists discuss the requirement that county need to respond to municipality concerns with proposed annexation? Does this requirement apply to all impacted municipalities or only the annexing city? Why do county only need to explain their vote only if rejecting a developer, but not explain vote in other circumstances? Well, I don't know if you can take that one.
Yeah, so the county, let's see. I'm trying to think when the county needs to respond to an annexing municipality, probably if there's a protest to the annexation, I'm guessing. There is a situation if there's a development proposed in the unincorporated county that the county needs to notify all of the municipalities that the property is included in their annexation policy area. And then those municipalities get a chance to respond on that. I'm trying to think of a situation where it might be the other way around, where the county has to reply or respond to a proposed annexation. Only time I think I'm aware of that would be if there's a cross-county annexation. And that, again, that's balled up in the issues that Victoria just talked about crossing county lines. Am I missing something there, Victoria? Did I?
Off the top of my head, I'm not thinking of one.
Yeah. I did see one other question just before that, which was asking about someone who was saying that they're new to the Planning Commission and that the owner has to initiate an annexation. They do under Utah law. The only situation that an annexation can occur without is if the property has been serviced by the municipality with urban services for more than a year, and then the city can initiate it without a petition.
Thank you, Will. Well, we are bumping up against lunchtime. I really appreciate the good questions we have, and want to personally thank Wilf and Jordan for setting aside their professional time to help us. I really am grateful for their wisdom and sharing this information today, so thank you. And we will be posting this later on, and Jordan's presentation, if he's willing to share that, on our website. So thank you all for joining us, and we hope to see you this afternoon at conference seminars, and really appreciate it. Thank you so much.